A unanimous Supreme Court decision just dropped. 9 justices, 0 dissents. And if you carry a firearm in your vehicle, this ruling changes the rules of every single traffic stop you will ever have from this point forward. Here is the part that should stop you cold. Most gun owners will not hear about this for months. Some will not hear about it at all. And a small number of them will find out the hard way, standing on the shoulder of a dark road, hands on the hood of their car, wondering why a completely legal firearm just turned a broken tail light stop into the worst night of their lives. That is not going to be you. Not after today. But stay with me, because this is not a simple story. There are layers here. There are things this ruling protects and things it absolutely does not. There are moments in a traffic stop where your knowledge of this decision will protect you completely. And there are moments where one wrong word, one wrong move, one wrong assumption will make this ruling entirely useless to you. Before we go any further, make sure you are subscribed. Rulings like this one get covered the moment they come down, not weeks later, not after it is already too late. Right now, while you still have time to understand it before you ever need it, hit that button. Let us get into it. To understand why this ruling matters so much, you have to understand the problem it was trying to solve. The United States Constitution gives you 2 separate and distinct protections that on paper should never conflict with each other. The Second Amendment gives you the right to keep and bear arms. That is settled. That is foundational. Millions of Americans exercise that right every single day, legally, responsibly, without incident. Then you have the Fourth Amendment. It gives you the right to be free from unreasonable searches and seizures. No government official can rifle through your car, your home, or your belongings without either a warrant or a very specific legal justification called probable cause. That protection is one of the bedrock guarantees that separates a free society from a police state. 2 rights, both crystal clear, both constitutionally protected. Yet for years they were quietly crashing into each other on roads and highways all across this country. Here is the collision point. When an officer learns you have a firearm inside your vehicle, what does that knowledge legally authorize him to do next? Can he search based solely on the presence of that gun, even if you have done nothing wrong? Even if the firearm is perfectly legal? Some lower courts were starting to say yes, and that answer was slowly becoming a crisis for every law-abiding gun owner in America. Lower courts were building a doctrine that essentially treated a firearm as a golden ticket for law enforcement. The logic, guns are inherently dangerous. Therefore, if a gun is present, the situation is inherently unsafe. Therefore, the officer has an automatic right to search. If the mere presence of a legal firearm automatically gave law enforcement grounds to search your vehicle, then exercising your Second Amendment right would simultaneously strip you of your Fourth Amendment right. You would have to choose. Be armed or be protected from unreasonable searches. Pick one. That is not what the Constitution says, but it was happening in real courtrooms affecting real people, and it was spreading. Cases like this one do not start in the Supreme Court. They start exactly where yours would, on the shoulder of a highway, under the flashing red and blue lights of a patrol car. Picture the scene. A driver is stopped for a minor traffic violation, a broken tail light, a failure to signal, a minor speeding infraction, nothing serious. The kind of stop that should last 5 minutes and end with a warning or a small fine. The officer approaches the window. During the interaction, it comes out that the driver has a firearm in the vehicle. The driver discloses it calmly. His hands are visible on the steering wheel. He is not acting erratic or nervous in any unusual way. He has done absolutely nothing that a reasonable person would look at and say that man is suspicious. But the officer makes a decision. He decides the gun itself is enough, that the presence of a firearm creates an automatic safety concern justifying a full search of the vehicle's interior. No warrant, no additional probable cause, no specific articulable facts pointing to a crime being committed, just the raw presence of a legal firearm. The driver objects, politely stating his rights. The search happens anyway. The case winds through the lower courts, and here is the part that should genuinely disturb you. The lower courts sided with the officer. They ruled that under the circumstances, the presence of a firearm alone was sufficient justification to bypass the Fourth Amendment. They basically said that being an armed citizen makes you suspicious enough to lose your right to privacy, one constitutional right used as a weapon to destroy another. Then it reaches the Supreme Court of the United States. And what happened there is something that almost never happens in modern American law. 9 justices representing every single ideological corner of that bench, from the most conservative to the most liberal, looked at this scenario and arrived at the exact same conclusion. 9-0. No splits, no partial concurrences on narrow grounds, no dissents, a complete, unified, across-the-board ruling. When the Supreme Court agrees 9-0 on anything involving firearms and law enforcement authority, you pay attention. That level of agreement does not happen by accident. It signals that the constitutional boundary being drawn is not subtle. It is not ambiguous. It is clear enough that 9 very different legal minds all landed in exactly the same place. Here is the core of the ruling, and every word matters. The mere presence of a legally possessed firearm in a vehicle does not by itself constitute probable cause to search that vehicle. Read that again. Legal gun ownership is not suspicious activity. Lawful carry is not evidence of a crime. Law enforcement cannot treat it as such. The highest court in the land told police departments across the country directly and unambiguously that you cannot use a citizen's exercise of one constitutional right as the justification to strip them of another. You cannot weaponize the Second Amendment against the Fourth Amendment. Those rights exist together. They stand together. And a law-abiding gun owner is entitled to both simultaneously. The justices reminded the government directly. Armed does not mean criminal. 9-0. Now here is where I have to slow you down. I know what some of you are thinking right now. You are thinking this ruling is a bulletproof shield, that the next time an officer approaches your window, you have a 9-0 Supreme Court decision, and that is the end of the story. It is not the end of the story. Not even close. Inside this historic victory, the Supreme Court left behind 3 massive hidden legal trapdoors. If you step on even one of them, your rights vanish instantly. These are the exact mechanisms that law enforcement, prosecutors, and lower courts will use to bypass your protections even after this ruling. If you do not understand them cold, you are walking into a minefield every time you turn your ignition key while armed. The first trapdoor is what we call the status requirement. The language of the ruling is remarkably precise. It states that the mere presence of a legally possessed firearm does not constitute probable cause. The critical phrase, the one that can dismantle your entire legal position if you ignore it, is legally possessed. This ruling is a shield built exclusively for lawful gun owners. It does not protect prohibited persons. If you are legally barred from possessing a firearm due to a felony conviction, a domestic violence restraining order, or any other disqualifying factor, this 9-0 ruling does not apply to you at all. But it goes deeper than that for the everyday carrier. If an officer develops what the law calls a reasonable suspicion that you are not legally supposed to have that gun, the firearm immediately stops being an innocent constitutionally protected detail and transforms into active evidence of a criminal offense. If your permit is expired, if your state requires a license you do not possess, or if there is a discrepancy in your background that flags in the system, the shield drops entirely. Your legal house must be in pristine order before you ever put the car in drive. That is the first trapdoor. The second trapdoor is the storage illusion. The Supreme Court strengthened your Fourth Amendment rights on a national level, but they did not abolish state-level storage laws. While the court ruled that a legal gun by itself cannot justify a vehicle search, an officer can completely bypass that restriction if the gun is stored in direct violation of a specific state statute. Consider how different storage laws are across state lines. In some constitutional carry states, you can have a loaded handgun sitting in your center console and it is entirely lawful. But the moment you cross into a neighboring state, the legal landscape can change completely. That new state might require that a firearm be completely unloaded, separated from its ammunition, and locked in a container located in the trunk, inaccessible to the driver. Here is that scenario made real. You are driving through a state with strict storage laws. You are pulled over for speeding. The officer shines a flashlight into your cabin and sees your legally owned handgun resting in an open center console. In that fraction of a second, the 9-0 ruling cannot save you. Why? Because the officer is not searching based on the mere presence of a gun. He has observed a plain sight violation of a state storage statute. The unlawful manner of your possession was the trigger, not the gun itself. This is where thousands of well-meaning, responsible gun owners get blindsided, and it is entirely avoidable with a few minutes of research before you ever leave your driveway. The third trapdoor is the most dangerous because it is the ultimate catch-all tool used by law enforcement across the nation, totality of circumstances. The Supreme Court did not abolish the automobile exception to the Fourth Amendment. Officers can still search a vehicle without a warrant if they have probable cause to believe it contains contraband or evidence of a crime. What the ruling means is that the gun cannot be the sole item on the list. It cannot be the only reason, but the firearm can absolutely be used as a building block in a larger legal argument. Picture this. You are pulled over with a legal firearm. By itself, the officer must leave it alone, but your passenger is acting intensely nervous, sweating, refusing to make eye contact. There is a faint odor of a controlled substance coming from the window. When the officer asks where you are coming from, your answer directly contradicts what your passenger just said. In a courtroom, that officer will not say he searched your car because of the gun. He will argue the totality of the circumstances. The firearm combined with the erratic behavior, the odor, and the conflicting statements created a combined profile of criminal activity. The court did not eliminate an officer's ability to piece a puzzle together. They simply ruled that a legal gun cannot be the entire puzzle by itself. Every other variable at that scene still carries immense weight. That distinction is everything. Now we arrive at the most psychologically dangerous moment of any traffic stop. It is not when the lights flash in your mirror. It is not when the officer steps up to your door. It is the exact moment the officer realizes he does not have enough legal leverage to force a search, so he switches strategies entirely and tries to get you to hand him permission voluntarily. He will sound completely reasonable. He will say something like, "Hey, since you let me know you have that firearm in the vehicle, just for my safety and yours, do you mind if I take a quick look through the interior?" It sounds harmless. And your instinct as a law-abiding citizen is to cooperate. You want to show him you have nothing to hide. Do not take the bait. The exact moment you say yes, sure, or go ahead, the 9-0 Supreme Court ruling is wiped completely off the table. Consent overrides the court. The Fourth Amendment protects you against unreasonable searches, but if you invite law enforcement inside, the search becomes reasonable by definition. You have handed that officer a blank signed check to go through your glove box, your center console, your trunk, and your personal bags. And here is the brutal truth. You cannot take that consent back in a courtroom. So what do you do instead? You need a step-by-step physical and verbal playbook. Because understanding the ruling is not enough. Knowing the trapdoors is not enough. What matters is what you actually do and say in the moment. The protocol begins the second you see those flashing lights in your rearview mirror. Do not panic, signal clearly, slow down smoothly, and pull over to the right shoulder as promptly as possible. Do not take half a mile to find the perfect spot. If you coast too long, the officer is no longer thinking about a tail light. He is thinking you are stalling or hiding something. You are building suspicion before your wheels even stop rolling. The moment your vehicle stops, execute these 4 steps in calm, rapid succession. Kill the ignition completely. Roll your driver's side window all the way down, and if your windows are tinted, roll down the rear windows too. Turn on your interior dome light if it is dark. Then place both hands flat on top of the steering wheel and keep them there. Do not reach for your registration. Do not reach for your wallet. Do not open your glove box. Do not touch anything until the officer is at your window and has given you clear instructions. A massive percentage of traffic stop escalations have nothing to do with complex constitutional law. They escalate because an approaching officer sees a driver frantically reaching into a console in the dark. A hand reaching for an insurance card looks identical to a hand reaching for a weapon. Remove that ambiguity before the officer ever touches your door. When the officer arrives and asks for your license and registration, do not make a sudden move. If your firearm is stored near your documents, speak before you reach. Say clearly and calmly, "Officer, my registration is in the glove box, and I want to inform you that I am legally carrying a firearm today. How would you like me to proceed?" Memorize that sentence. That single statement achieves 3 critical things simultaneously. It demonstrates complete transparency. It removes the element of surprise from the equation. And by asking how he would like you to proceed, you place the responsibility back in his hands and signal that you are a responsible, structured, law-abiding citizen. Most experienced officers will recognize that professionalism immediately, and the entire energy of the stop will shift. Before any of this, you must know your state's disclosure laws. Some states operate under a strict duty to inform, meaning you are legally required to volunteer the presence of a firearm immediately upon contact. Failure to do so is a criminal infraction that instantly strips your protections. Other states have no such requirement. Know the law of the state you are driving in right now. And regardless of what that law says, if an officer asks you directly whether there is a weapon in the vehicle, never lie. A single provable falsehood to law enforcement turns a routine stop into a criminal investigation faster than almost anything else that can happen at a car window. Now comes the defining moment of the entire encounter. The officer runs your information, hands back your documents, and then pauses. He leans slightly into the window frame and delivers the line. "Hey, do you mind if I just take a quick look inside your vehicle?" You do not stutter, you do not get combative, you do not quote Supreme Court decisions or act like a roadside lawyer. You respond calmly, respectfully, and without hesitation. "Officer, I respect the work you do, but I do not consent to any searches of my person or my vehicle." That is the complete statement. Stop talking immediately after saying it. The officer may push back with, "If you have nothing to hide, why not just let me look?" Recognize that for exactly what it is, a psychological pressure tactic designed to make the exercise of a constitutional right look like an admission of guilt. Maintain your composure and repeat, "I am choosing to exercise my Fourth Amendment rights, and I do not consent to a search." Then embrace the power of silence. Do not fill quiet moments with nervous explanations about where you are driving from. Do not volunteer answers to open-ended questions. You can simply state, "I prefer not to answer additional questions." Most people talk themselves directly into a vehicle search by providing the exact conflicting details an officer needs to build probable cause. Silence removes every one of those building blocks from the table entirely. Understand the officer safety boundary. Under long-standing precedent, an officer may order you out of the vehicle during a stop for basic safety reasons. Comply if asked. Step out calmly. Keep your hands visible. Follow instructions precisely. But if he then attempts to search the vehicle, you state again, "Officer, I do not consent to any search of my vehicle." What this ruling heavily restricts is the officer expanding that brief safety exit into a full search of your car's interior. Previously, courts allowed officers to use the phrase safety check to visually sweep the entire reachable cabin area almost every single time. Now, officers must articulate a specific, concrete, objective threat, not just point to the abstract presence of a legal firearm. That distinction is where this ruling does its heaviest lifting for you in the real world. Body cameras work in your favor if you handle the stop correctly. When you clearly refuse consent, that refusal is on camera. When the officer searches anyway, that is on camera. When you remain calm, that is on camera. Every step taken after your explicit refusal is now under intense legal scrutiny. If the officer searches your vehicle anyway despite your clear refusal, do not physically resist. State clearly and loudly, "I am not physically resisting, but I do not consent to this search." Then let his actions speak for themselves. If the search was unlawful, any evidence discovered becomes what courts call fruit of the poisonous tree. Your attorney can move to have it suppressed and thrown out entirely. Your composure on that shoulder is not weakness. It is the foundation of the legal case you will win later. The moment the stop ends and you are cleared to leave, pull into the nearest safe parking lot immediately. Open your phone and record a voice memo while your memory is still sharp. Document the exact time, the location, the officer's name and badge number, the reason given for the stop, the exact words exchanged, whether you consented or refused, and what the officer did after you refused. Do not trust your memory. Stress degrades it faster than most people realize. The specific details you record in the first 5 minutes are the exact tools a defense attorney will use to dismantle the state's case against you. If you were arrested, the rules shift significantly. Do not resist. Resisting is a separate crime that compounds everything. Stop talking entirely. When you are placed under arrest, the officer will read your Miranda rights. That is not a suggestion. That is a warning. Everything you say from that moment forward is evidence. Say this and only this. "I am exercising my right to remain silent. I want to speak to an attorney." Then stop. Nothing you say will help you. Everything you say can be used against you. When you get your phone call, you call an attorney. Do not discuss the case details on a jail phone because those calls are recorded. When you appear before a judge, enter a plea of not guilty. Every single time, regardless of what you believe about the evidence. This gives your attorney time to examine the search and file motions to suppress anything obtained unlawfully. The exclusionary rule is one of the most powerful legal tools available, but it only functions if you have a clean record of refusing consent behind you. Now let us talk about what you should be doing before you ever get behind the wheel. Know your state's carry laws inside and out, not just the basics, but the details. What are the storage requirements for a firearm in a vehicle? Is your permit current? Are there any location restrictions? Understand reciprocity if you cross state lines. Your home state permit may not be valid in the next state. Use verified apps and cross-reference State Department of Public Safety websites before you leave. In some states, a firearm stored legally at home is a criminal violation the moment you cross the border. Prepare your vehicle. Keep your registration and insurance current. Make sure your lights are working. A broken tail light is an invitation to be stopped. Eliminate the minor things that hand an officer a reason to approach you in the first place. Practice your statements out loud until they feel natural under stress. The more you rehearse under calm conditions, the less you will panic when it truly matters. The Supreme Court just handed law-abiding gun owners one of the most powerful constitutional affirmations in modern history. 9 justices, representing the entire ideological spectrum, stood as a unified front to tell the government and every law enforcement agency in this country that you do not have to surrender your Fourth Amendment right to privacy simply because you choose to exercise your Second Amendment right to bear arms. You are entitled to both simultaneously, without condition. But rights written on paper mean nothing if the citizens they protect do not know how to exercise them correctly in the real world. This ruling only works as a shield if your possession is 100% lawful. It only holds up in a courtroom if your roadside encounter was handled with composure and precision. It only protects you if you did not hand the officer a sword by consenting, by lying, by reaching unexpectedly, or by letting panic make your decisions. Think about the weight of that. Millions of Americans go through background checks, training requirements, and application processes specifically so they can carry lawfully and responsibly. These people are not threats. They are not criminal suspects. They are free citizens exercising a right that the supreme law of the land explicitly protects. This ruling draws a permanent line. The armed citizen and the criminal suspect are not the same thing, and the government may not treat them as such. Carry that with you every time you put the car in drive. Calm hands on your steering wheel. Clear communication when the officer approaches. No sudden movements. No voluntary consent. Know your carry laws. Store your firearm in compliance with the laws of wherever you are standing. Because if your possession becomes unlawful for any reason, an expired permit, a storage violation, simple lack of preparation, the protection this historic ruling provides disappears entirely. No amount of Supreme Court history will bring it back in that moment. Most people who carry a firearm daily will never see a breakdown like this one. They will learn about their rights only after something has already gone wrong, after the search, after the charges, after it is too late. You are not that person. You paid attention before the crisis. The next time those lights flash in your rearview mirror, you will know exactly what to say, exactly what to do, and exactly how to protect the rights that are designed to protect you. Stay informed, stay calm, stay lawful. Because in this country, constitutional rights are only powerful in the hands of citizens who understand exactly how to use them.